The court is in session in the case of State of Juristan versus Armagan Randawa. The prosecution, you may proceed.
Good evening, respected judges. Good evening, respected judges. I am Fahim and I am appearing on behalf of the prosecution, the State of Juristan, along with my co-mooter, Ms. Shagufta Ramzan, and legal researcher, Mr. Ahmed Nawaz Khan. Respected judges, I will be dealing with the first three questions that are, the first question is the question of jurisdiction. The second issue is whether the killing of Dilrozen Qazalbash was murder considering the circumstances or not. The third issue is whether only Armagan Randawa is liable for killing of the Qazalbash or not. Now turning to my first submission. Your Honors, as far as the matter of jurisdiction is concerned, I will make two submissions regarding this issue. The first submission, Fahim. My first submission will be regarding the jurisdiction under local law, and second submission will be regarding the jurisdiction under international law. Now I turn to my first submission. Your Honors, we submit that Honorable Court of Juristan has the jurisdiction to try the instant matter under the Section 3, read with Section 4 of the Juristan Penal Code. I state the Section 3 of JPC that says punishment of offences committed beyond by which the law may be tried in the Pakistan. Read with Section 4, that is extension of court of two extraterritorial offences. And subsection 1 of Section 4 says any citizen of Juristan or any person in the service of Juristan, in any place without and beyond the jurisdiction. Your Honors, the prosecution seeks jurisdiction under the Section 3 and 4 of the Juristan Penal Code. As the fact suggests, respected judges, that the above mentioned provision of JPC establish very firm grounds over the matter of criminal jurisdiction in this case. Section 3 and 4 of the JPC state that it is applicable to any citizen of Juristan or any person in the service of Juristan. And as the facts of the case suggest, the four crew members in the vessel were on the high seas on behalf of the Juristan, and Dilrozen Qazalbash was killed during his services for Juristan. Thus, these facts indicate that the JPC is applicable to this case and that the crew members may be prosecuted for the murder of Dilrozen Qazalbash. As of the service of Juristan, I would like to state the facts to the honorable judges that the federal government of Juristan hired the services of Armagan Randawa and Dilrozen Qazalbash, who are the nationals of a neighboring country, Nana, for research purposes on the high seas. Additionally, the state of Juristan hired the services of Zizu Company and it contracted with Zizu Company. Zizu Company is a foreign agency whose main registered office is in a neighboring state, which is Dilaram. Zizu Company provided resources for the voyage on the sea. The company provided 2 crew members, including the vessel and all other equipment necessary for the voyage. Your Honors, Firoza Bill and the captain of the ship, Aruza Gill, are the nationals of Dilaram, but they were in the service of Juristan. Therefore, according to this code, the Juristan Penal Code, both Aruza Gill and Firoza Bill, along with the vessel, were in the service of Juristan and are under the criminal jurisdiction of Juristan.
Can I interrupt you for a second?
Yes, please.
This contract has been signed on first room close of Paris, right?
Definitely.
Then they went in April 2023, right? And they remained there up to 25th May 2023 when they last contact with the people in Juristan. And after that they are 20 or 22 days, they are in deep seas. Now can we not say that this contract has been expired?
Definitely, Your Honor. I accept this fact, and I want to submit that, we want to submit that their contract was expired according to the facts, but they were still on the ICs, and they had not come back, and they had not submitted back to the state of Juristan. So therefore, in that sense, they were still in the service of Juristan, so therefore they are under the criminal jurisdiction of this court. Now I turn to my second submission, and that is the jurisdiction under the international law. Your Honors, our submission is based on the principle that is laid out in the Lotus case. I request my researchers to provide the case. Laid out in the Lotus case, which states that if there is no specific rule mentioned in the international law, the state can extend its jurisdiction through local law. This is supported by the Article 59 of UN Clause, United Nations Convention on the Law of Seas, and the UN Clause Article 59 says, basis for the resolution of conflicts regarding the attribution of rights and jurisdiction in the exclusive economic zone. Your Honors, UN Clause gives the sole rights as regard to jurisdiction to the states and to resolve the disputes, because the UN Clause does not explicitly and clearly address the issue of criminal jurisdiction or the EEZ or exclusive economic zones and ICs, and there is no single clear universal accepted answer to this question, to the question of criminal jurisdiction or the ICs. Your Honor, the other principle that we submit before this honorable court, that the other submission we are making is regarding the universal jurisdiction. This principle of universal jurisdiction states that a state can exercise jurisdiction when there is no connection with the crime at all. The state has no connection with the crime at all, but it can still exercise this principle. But this can only be done if the matter is international crime and related to jus cogens norms. Your Honor, the jus cogens norms are certain fundamental overriding principles of international law, and these principles cannot be set aside. These principles of international law binds all the states, and these are the laws prohibiting genocide, crimes against humanity, and torture. As of the facts, the crime against humanity was committed here on. Definitely, sir. Definitely, sir. Facts में clearly ये mention नहीं, वो signatory है, लेकिन facts में ये mention है कि UN clause area set करता है on seas, तो इससे ये हम ले सकते हैं कि definitely वो एक member है. The state of Juristan is a party to the Rome Statute of International Criminal Court, which clearly recognizes the principle of universal jurisdiction for the crimes of genocide, crimes against humanity, and war crimes. Therefore, Your Honors, Juristan has the legal basis under the principle of universal jurisdiction to try the instant matter of Armagan Randawa and others against the murder of Qazarbash. The principle of universal jurisdiction is an important tool for ensuring the criminals are brought to justice. And Your Honors, we want to submit here on that as of the facts, the state of Dilaram was in a active state of war. So, according to the facts and according to that matter, the Dilaram might have not been able to initiate a trial. So on that regard, on that account, the state of Juristan serves as a responsible country, as a responsible state to start the trial.
For the sake of argument, अगर जुरिस्तान की jurisdiction बनती भी है यहाँ पे, for the sake of argument, अगर बनती भी है, अगर मायना इसको try करे या इसको जुरिस्तान try करे, यहाँ पर मकसद जो है वो सिर्फ to penalize the culprits. What is wrong with it?
डेफिनेटली सर, ये आप बात बहुत सही कह रहे हैं, लेकिन कुछ चीज़ें होती हैं जो हमें लॉ कहती है और हम अबाइड बाय द लॉ है करनी है। तो हमें लॉ ये कहती है कि अगर वो क्रिमिनल्स आपके जुरिस्डिक्शन में बनते हैं तो फर्स्ट हक आपका बनता है, फ़र्ज़ एक्चुअली आपका बनता है, आप उनको ट्राई करें। Unless there are any further questions on this submission, I now turn to my second question. Yes. Whether the killing of Dilruzan Qazalbash was murder, considering the circumstances of this case or not. It is humbly submitted before the Honorable Court that the accused Armaga Randawa had committed the offense of murder and guilty of charges. The section 300 defines the essential elements of the commission of murder, and the accused, Your Honors, and the company fulfill all the essential elements of murder mentioned in the provision. The elements are as following. The first element is the mens rea, the evil intention. The second element is the actus reus. Third element is the concurrence or the agreement or union in action. The fourth element is causation, and fifth element is harm. Basically, Your Honor, the act of murder is defined as unlawful killing of a human being with malice aforethought. And in this case, the conversation that is mentioned in para 9 of the facts between Armagan Randawa and Firozabil make it very clear that the murder of Qazalbash was premeditated and falls in the category of intentional killing. Furthermore, considering the question of circumstances, Your Honors, the excuse of the killing of Qazalbash because of the prevailing circumstances is not justified by any means. Even though the crew was facing starvation and dehydration, they didn't have any right to kill an innocent and an unoffending person in order to preserve or in order to save their own lives. Moreover, the crew members were not in an imminent threat of death, so they cannot claim the defense necessity or necessity defense. They could have tried to survive on other means as they were young people and their body was adaptable to survive more of the days, around 3 weeks or 4 weeks without food or water. Such as sea animals and rainwater, they might possibility have been picked up next day by a passing ship. There was possibility and there was no imminent threat of death. So there was no necessity. This is what we are trying to submit, Your Honors. And they could have tried to signal for help or seek help by any other means and similar methods. Now I turn to my third question, that is whether only Armagan Randawa is liable for the killing of Dilruzan Qazalbash or not. Your Honors, it is humbly submitted before the Honorable Court that the facts prove that Armagan Randawa was the ringleader, he was the one who provoked the crew members, and he was the instigator of the killing. He was the one who proposed the killing, and he was the one who proposed that one should die to save the others, and he was the one who ultimately killed Qazalbash. Your Honors, Randawa was motivated by a desire to save himself. He apprehended death, and that he did not care about the life of Dilruzan Qazalbash. Because in para 9 of the fact, it is mentioned that he kept encouraging his crew members to find a way out or to draw lots, to select a person and to kill him and ingest his flesh. However, it is also found that Firozabil and Arozagil were culpably involved in the killing. They both were present. They both were present when Qazalbash was killed, and they did not attempt to stop it either. Even Firozabil was standing next to El Randawa if the victim resist. It is mentioned in para 10. This shows that she was actively and intentionally involved in killing, and this whole scenario indicates that they were willing to go along Randawa's plan. Therefore, they share sheer responsibility for killing and may be held for.
You mentioned joint enterprise liability. Would you assist the court regarding this liability?
The joint enterprise liability refers that if a person commits a crime, then the person abetting that person may be held with the same charges or with the same punishments. Moreover, the circumstances and evidence signify that the killing was premeditated, because when Qazalbash fell into coma, Randawa and other crew members discussed possible killing of Qazalbash because according to them he was an orphan and didn't have family. Your Honors, he was not an orphan, or it was not that he didn't have a family. He had a girlfriend, Mashupali, that was waiting on his return that they would have married. Your Honors, I am almost done with my submissions. Unless there are any further questions, I request my co-counsel to proceed. May it please the court.
Good evening, Your Honors. I am Shagufta Ramzan here on the behalf of Prosecution Counsel, and I will be assisting the court with the remaining issues. Our fourth issue is that whether cannibalism is lawful under the theory of necessity or not. According to the facts, both Armaghan Randhawa and Dilrozain Qazalbash are the followers of Shanshu religion, and that religion, under that religion, act of human flesh eating was permissible under some certain circumstances. It is to be noted that as far as the act of cannibalism in this religion is concerned, few vague historic accounts of cannibalism under this specific religion are found. There is little ambiguous evidence that cannibalism was practiced in earlier Shanshu Buddhism, but it is not clear how widespread and accepted the practice was. Can I have few more minutes because I am addressing a crucial... Thank you. But it is not clear how widespread or accepted the practice was. Some of the earliest resources that mention cannibalism in Shanshu Buddhism